Hello, everybody. This is Juan Carlos Brando. Thank you for joining us today in the show of the attorney Margaret W. Wong, who has been working on the immigration field for over 45 years in the United States, and she has helped thousands of families every year and every month, actually, getting them work authorizations, asylum cases, family petitions, work based visas, tourist visas, and a lot of uh, situations that come to the people in the United States when they are immigrants or when we are immigrants, and we need to relieve or to solve our situations with the immigration system. So, if you have any questions today, please feel free to send your question through our Facebook Live or through our YouTube, and the attorney Margaret W1 will be able to answer today. So let's welcome the attorney Margaret Wong, and you are welcome to send your questions. Good afternoon, Ms. Wong. Thank you so much for having us today. How are you doing?
I'm good, thank you.
Thank you so much, Ms. Wong. Well, just to start, there are a lot of proposals going on with the immigration system. The government is asking for a lot of proposals. They are proposing stuff to the Congress, to the House, but sometimes uh, there is nothing after the proposal. So, what do you think is the moment that we are living in the United States in regards of immigration?
Right now, I don't see too much changes or even any change because right now, whatever President Biden does is under attack. President Biden actually wants to continue the Title 42 because that's where you remain and you can't allow the whole world to come to America illegally. And that's why he wants to keep Title 42, the remain in Mexico now, of course, it was shut down. But then if he takes away Title 42 and really stop people from coming, then the liberals would attack, say that that's why we voted you to be nice to people. So I think he's not in a good place. And that's why, as human beings, I don't even need us to worry about what our government is doing. I just want I mean, of course, we need to worry. And also the COIL memo, the April 25th, 2022 memo is gone because a Texas court say no more. Even on vaccination, Dr. Fauci is saying that he's retiring, which I'm going to miss him because I thought he's just such a wonderful doctor. I mean, he's kind, he's gentle. So things are changing, but absolutely we need to protect not so much the border people that came in because they know I think with today's Google work, they know what they're getting to. We really need to at least let the people keep work permits, keep their social security number, let them file tax return, let them have a driver's license on people who have been here in America for more than 5 or 6 years or 10 years, like the DACA people, at least give them some work permit or something so we can live and survive. I'm not talking about giving us citizenship or green card, but we need something. Because even the COIL memo, before it was shut down, is saying that they don't want us to do admin close. They only want termination and dismissal, which is nice because that means that you won the case. You're not going to be deported. But the bad thing is there's no more work permits. There's no more other benefits that go along with having a case in court. It's just aggravating.
Okay, thank you so much, Ms. Wong, for this answer. And well, we're having a lot of rain today here in Atlanta. It's a very strong storm this morning and throughout the whole day. Some thunder, lightning, and everything that is going on. So it's a nice day, but it's a little bit weird because we get a lot of accidents on the roads, and we get a lot of people just grabbing their phones and sending their questions to this show. So let's see this question here. I'm trying to petition for my mother who had been deported back in 2017, and her sister's petition was approved on 2019, and nothing has happened on that application. My mom obviously did not leave the country when she was granted probation and to stay in the States while case was pending. She doesn't want to wait any longer and would like to know if I can apply for her. I am an US citizen for 9 years on July 19, and her mother is a permanent resident card holder. Uh, my mom is afraid that she might be um, denied because of her deportation back in 2017, um, per another consultation with attorney he gave. So I
So,
don't.
right. So
Yeah,
is the mother still in America, or the mother left America and was
she's
deported?
still in America.
Okay, so when he said the mother was ordered deported, does that mean the mother have a criminal record? So she has a final order of removal, but she never left. Is that what she meant? Because I don't really understand this question.
I think she had a removal order
Mhm,
back in 2017, and she filed the I-130 for her mom.
mhm.
So the thing is that since they are waiting to do the I-485 petition,
Did the mother something about green card? Did the mother ever got green card, or the mother never got green card?
she never got green card.
Okay, so how did the mother come to America, legally or illegally? Did she say that?
Um, she doesn't say here.
Right. I wonder why okay, what country are they from? Did they say?
Mexico.
Okay, so let me tell you what I would do on this case. Number one, do the FOIA. Why did the mother have deportation or removal order? And did she ever have a perm bar? So if you decided she didn't have a perm bar, it's only a removal order, then we need to find out how did she come to America the first time? Did she leave and come back, leave and come back? If she came legally, now is a great time because even though the COIL memo was shot down, you can ask on totality of circumstances to OCC to reopen the case and get your mom a green card if she entered legally. If she entered undocumented and with no papers, then you have to see if her parents have green card. That means your grandparents from your mother's side have green card, or if your dad have green card, your mom's spouse or a new spouse. If they have a green card and she has no perm bar, then you already have an I-130 filed. So you need to do a 601A from either her new spouse who's a green card or citizen or her parents who are green. These are very simple cases. Number one, how does she enter? Legal entry overstay, final order, you do a motion to reopen or joint motion requesting OCC to join you to reopen and get a green card right away after I-130 is approved. If she enter undocumented but never left and come back, but have a removal order, then she would not be able to get a green card. But if she entered it undocumented, but her parents have a green card or citizen, then you need the parents to give her a 601A to get a green card. And I understand her frustration that she's tired, she wants to go back. Absolutely. If she wants to go back, she has a deportation and she had been here illegally, she can always come back after 10 years because you are an American citizen. You can always petition and sponsor her but she has a 10-year bar because it doesn't, if deportation only give you a 10-year plus also an undocumented stay give you 10 years. So this is actually a very normal, that's why American immigration law has to change. There's no reason for old people like us to stay in America without papers, without green card. If my child is already over 21, I don't have a family to go to because I came here 30 years ago. The law is it doesn't matter when you come, if you came undocumented, you never get a green card in America and you have to leave and come back. That's Obama law. But even if you leave, could you come back? You need parents or spouse to give you a pardon. If not, you cannot come back in 10 years. It's that simple. This is what we call the perm bar. This only affects Mexican people because the Chinese, the El Salvadorians, the Venezuelans, the Brazilians, the Cubans, we don't leave because it's too far. It's only the Mexicans and the Canadians who leave. The Canadians, you don't need a visa to come anyway. So they have no perm bar. It's only the Mexican people that suffered, and that's not right. And I strongly recommend, Mr. Preston, you've been listening. I know you don't listen to a little radio show or Facebook show, but you need to change this law. This question exactly is what people like us are going through it.
Yeah, that's true, Miss Wong. And this person says that apparently she spoke to another attorney before and says that this attorney is giving her the 50% chance that she will not be approved because of that removal order. And how can she proceed with this without having her mom go back to Mexico? Because the thing is that she's an U.S. citizen since 9 years ago, and her mom, uh, her grandma, is green card holder. So
Oh, so the mom's mom is a green card holder. So definitely, no, she will come back as long as there's no 6E, because a lot of people like your mom, because you're a citizen for 9 years, that means you're not born here. It could be your mom, save up money and brought you, pay the trip to bring you here. That's a 6E. That's an illegal transport, especially in Mexico, because we all do it. We all bring our husbands, our children to come to America illegally. So Mexico would ask, did you ever pay for the trip? If she say yes, then she's stuck there for only for 1.5 years, because she can still do a waiver, because the person she brought in is a child, I mean her blood relative. So anytime you bring in spouse and children, it's a 6E, that's a pardon. If you came to America before 97, you don't even need a pardon, but after 97 she will need a pardon. So but if her mother is a green card, you already got it. She doesn't want to leave, but don't be afraid of leaving. If there's no problem, she needs to, but it still take 4 years. So I presume that I-130 is approved. You did not pay the $120, 300. Pay it now. Do the 601A. It'll take 2 years from the grandparents. I think you'll be fine.
okay, thank you so much, Miss Wong, for this answer. Is a kind of complicated case, but thank you so much. Don't forget that Miss Wong has offices in 9 cities of the United States: in Atlanta, Chicago, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is 216-279-3984, 216-279-3984. Hello, I am 17 and my brother is 19. We came on a tourist visa 9 months ago. There's a citizen person who wants to adopt us, and we are currently in the United States. Can he do this? How does this work? Thank you.
There are two laws that the answer is no, because adoption has to happen before the age of 16. The only exception is if your sibling is under 18 and you are over 16, then if they adopt both, but your sibling is already 19, so the exception does not apply, so the answer is no. But even if the answer is yes, there's a Hague Convention, depends on what country you're from, and that makes adoption practically impossible now.
Okay, thank you so much, Ms. Wong, for this answer. And well, there are some ages that we need to be aware of. So thank you so much. The phone number is 216-279-3984, 216-279-3984. The next question is, um, I filed my asylum case, but my attorney didn't include my husband in this case. We, what can we do? We have two kids born here, and he's been living in the States for over 20 years, no records. How can we get him a work permit for
You
him
can file
using my
as
asylum application?
if the only question is what happened if you filed asylum and you did not include your husband can always file a separate one. You don't have to be joined together, but it's more than 20 years. To win asylum, you have to file within 1 year, but you do have kids. So if you file the asylum now, when you get to court, you can always fight under 10-year cancellation, but you need to make sure the claim of asylum is non-frivolous, is credible, it passed the smell test, because immigration doesn't like it if we just file asylum, just for a work permit. They don't like it, and that's a problem. Right.
Okay, thank you so much, Ms. Wong, for the answer. And this is interesting, Ms. Wong, because some people that are coming through the border in the south border, they also want to apply maybe for the labor cert. But is that possible for people that came through the border, was paroled in, they filed for asylum? Is that possible that if they find a job, that this employer could file the labor certification or the perm for them?
Yes, the employer definitely could file the perm and the I-140 for you, which is the labor cert. The labor cert right now is 3 steps: prevailing wage, advertising, and the filing. Now it takes 7 months for approval after you file, and 6 to 7 months, actually 8 months sometimes for prevailing wage, and the advertising is about 6 months. So total is about 1.5 years. Then you file the I-140. No problem, but it's the green card. So if you enter undocumented, but if your parents have green card and citizen, you can always do the 601A from the parents or your spouse if he's or she is an American citizen or green card. Then you leave the country and come back after 2 weeks. So it's still the same process as if you married an American, married a green card. But married an American, married green card is I-130, employment base is I-140. So you should be getting the green card in less than 5 years if you go this route. But provided your spouse or your parents have green card citizen to do the 601A waiver. If you don't have parent or spouse or a citizen, brothers or citizen or green card, because then even if your parents have no papers, your sisters and brothers can get parents' green card to give you a pardon. But if you don't, if you couldn't do that, and most of us who came first generation are not lucky enough. Their grandparents and parents were green card or citizen. So then don't bother with the perm and labor cert. You're just wasting money.
Okay, thank you so much. And actually, Ms. Wong, we're having another question that says, I entered on a parole, and
Good.
yeah, so this person entered with his kid, and he filed the asylum application. They have a court date for January 2023, but he did his fingerprint appointment, but his kid, who is 15, never received the appointment notice or the fingerprints notice. How can we do to get him do the fingerprints
Right.
notice, or he doesn't need to do that?
Fingerprint notice invitation have to come from you, from immigration or USCIS. Even the ICE have to ask CIS to give you a fingerprint notice for you to go in there and take it. So my recommendation, a court is coming up, maybe, and also if the kid is only 15, anytime they're under 16 or 14, it depends on the office, they don't ask for fingerprint. So it could be immigration forgot about it, number one. It could be also when you fill your 589, I don't know if you get a work permit or a kid get a work permit. If you didn't get a work permit, I would also check the asylum application, because some of us, we forgot to put in as a kid, because you have to say yes and then put in the kid's name. And during the interview, was a kid there? Because you could have asked the officer during the interview, because you already went to court. So it could be a defensive filing. So these are all questions more for immigration lawyer. These are strategies. Sometimes you don't want fingerprints for the kids, because then there's no record that fingerprint. I mean, you should if you're going to win the case, but if you're going to lose, then the kid have no record, and there's no fingerprint record. That makes a lot of difference. Also 15, we don't know if it's intentional, they didn't ask fingerprint, or they don't need a fingerprint because at the border he probably took a fingerprint because you and him entered undocumented. Yeah,
I guess I got a part messed up, because it says that they entered illegally.
Right. So I don't know if they were stopped at the border, because if they were stopped, they would have taken prints for anybody over 12. Maybe they're reusing the print. But my recommendation in the next interview or hearing, and notify the court lawyer, the ICE lawyer, the OCC, that your kid never took a fingerprint. They will take care of it for you. You need that invitation. You need that notice to go take biometrics.
Inspection. With my family, I have attended all the reports before ICE. 15 days ago, I put my finger notice and my biometrics, except for my son, who's a teenager, that he never got the finger notice. I had the credible fear interview, and I already have a court in January 12th in Memphis.
good. So you know what you're doing. That's awesome. My recommendation is you need to stop saying you are enter without inspection. You have been inspected because you came in by volunteering on the line or you were stopped at the border. Inspection means that you came undocumented. You were never arrested. You were never stopped. You never went to immigration. In this case, you passed credible fear. It's also a defensive filing. So you actually enter with inspection, but were not admitted or paroled. So the NTA should be the third square, not the first or second square. The first square is arriving alien. Second square is arrived undocumented, totally illegally. Third is arrived without parole or admission. You have been inspected because you showed who you are. You sat in jail. You went through the credible fear case. So that's only one correction I have on your question. But aside from that, everything is good. So whenever you go to court, just tell them your kid didn't get fingerprint notice. That's fine.
Thank you so much, Ms. Wong. Don't forget that Ms. Wong has offices in 9 cities of the United States, in Atlanta, Chicago, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is 216-279-3984, 216-279-3984. Robin asks, how can I send new info about the new police report for my EU visa filed in 2020? 3 robbery, but new 4th robbery
You
happened.
can attach the police record. You don't need a new, it doesn't hurt to use your receipt and attach the new robbery. Better yet, it also doesn't, I know I did this quite a few times and probably immigration hates it, but I would do it. If it's a 4th robbery, if immigration is willing, the police is willing to sign another 918B, have them sign another 918B, just amend your original 2020 filing. I hope you filed your C14 with it because you should get a work permit within 1 year to 1.5 years or within 9 months after date of filing. New law just came in from Biden on this. I would just use the receipt notice. If you could get another 918B signature, that would be awesome. So now you have 2 signatures. If not, it's okay. Just attach it and send it in on the address on the receipt notice.
Thank you so much, Ms. Wong, for this answer. And Ms. Wong, just another question that someone is asking here through our Facebook. Attorney, when I presented myself in the Embassy of the United States for the interview on December this year, on December last year, they accepted all my paperwork that I brought in, and they said that there was no problem with that. I think that for the waiver, they requested me. They said that I lied to an officer about the question that he said about if I ever went to the United States, and he says that I lied. But my concern is I don't remember, or I didn't remember that I went to the United States. I tried for a tourist visa for an invite that I was given in 2014. But the error that I committed was to lie to the officer when he asked me if I had gone to the United States illegally.
Okay, I already got it. So let me tell you your problem. You probably got a 221G letter. 221G letter means that probably this case will be denied. You have a perm bar because basically what you did is you went to immigration, applied for tourist visa in 04. That means you were there. You probably were in America, and they say you applied, which means that you probably were in America in 01, 02, 03. So a lot of times on the form, as I told every time I see this, I do this program, not every time, but a lot of times, make sure on the form they ask you, were you ever in America? You say yes and no. And how many children do you have? You say yes and no, because a lot of our clients, they'll say no, were you into America? How many children do you have? None. They turn out you have 2 American kids. And now the American kids are sponsoring you. So, but at that, they have records for everything. Years and years ago, and I've been doing this for 45 years, They don't keep records of DS-160. They just guess. Now it's on computer, on record. So you have a perm bar. And I feel bad for you because you probably were here in 01, 02, 03. You went back. Hopefully, if you get the tourist visa, come back. They denied the tourist visa. So you must have been here after you got denied the tourist visa, because otherwise, how are these kids born? Where did you get a tax return? It's a perm bar case, which means that you probably, I mean, if my guess is right, if you were here for more than a year before before '04, when you filed the DS-160, they won't let you come back for 10 years because there's no waiver for this, even though your wife may be a citizen. That's why you went back. My gut is you got a 61A approved. You thought everything is okay, so you went back to get the interview for 2 weeks. Remember the other client I said you just go out for 2 weeks and come back? These are cases where I would not have gone if I were you, because now you're stuck out there. You couldn't come back, especially they already said we have lied. The only way to come back is either is illegally, but they're really bad at the border now, very dangerous, very sad. You already have a perm bar, and I'm really sorry about that. And plus the fraud waiver, even after 10, perm bar only means they cannot come back for 10 years. After 10 years, you still need a parent, a spouse, give you a pardon for this fraud waiver. Fraud waiver have no statute of limitation. That means even if you want to come back after 20 years, you still need a waiver for fraud. But for perm bar, you only need 10.
Okay, thank you so much, Ms. Wong. This next question says the following. This person, I am concerned about lottery emails. If I haven't heard anything from USCIS, what's the next step? I didn't get accepted in HIB lottery. I would like to apply for H1B now. I am in Thailand now, Indian passport.
I'm so sorry. That means that you have to wait. If you get a job, keep looking for job offer. If you get a job offer with universities or colleges or not-for-profits attached to universities or colleges, it's year-round. You don't need to wait for lottery. But if you didn't get into a lottery, that means that you have to get maybe the same job in February. Now it's only July, so you have to wait for next February, the coming February, to reapply to get into the lottery. And then by April 1st to April 5th, file a new H-1B and come back to America after September 15th if you got into the lottery and got the H-1B.
Okay, thank you so much, Ms. Wong, for this answer. Don't forget that you can call the attorney Margaret W. Wong, and they have attention in many languages. I think it's 30 languages that are spoken in the office, Ms. Wong.
We speak a lot of languages.
Yes, there's a lot of languages. So it doesn't matter if you call and you speak Italian or you speak French, Portuguese, Mandarin, Cantonese, Hindi, English, Spanish. What other languages? Vietnamese. Well, the Russian, Albanian. Well, there are a lot of languages that are spoken in the office of the attorney Margaret W. Wong. So you can call, they will take care of you and of your case. They will check what the best option for you is. And Ms. Wong, I have a question, because a lot of people ask me this question since they see that I talk with you and that we have this Q&A show. Some people want to enter through the border either from Mexico or from Canada. But for a person that comes from Europe, Africa, Asia, is it good or is too bad to enter through the north border of the United States? I mean, through Canada.
There's no easy border. In the olden days, most Indian people like to come through Canada. Most southern border people like to come to Mexico and Arizona. So now there's no easy border anymore. My advice is try not to come undocumented, because it's not like years ago, we come, we pay a bond of $5,000, we get a work permit, or we just work undocumented. And after a few years, laws change and 245I. Those laws are gone, and now it's difficult to get a job offer, or even do a job without work permits and without, people are suffering here. So on the other hand, I've also hear a lot of people tell me, I mean, the American embassies are all closing for tourist visa. That's another reason. People sometimes their father is dying, they need to come visit their parents who is sick, and the American embassy are closed. They can't even get a tourist visa or humanitarian parole or stuff like that. So it's a promise like I punch you, you punch me back, 2 times, and I punch you 3 times, you punch me back 4 times. So the more American embassy won't give tourist visas or humanitarian parole, the more people want to come undocumented. But once they come, they're stuck here because if they go back, they won't ever come back, even after 10 years, because they couldn't. So people then are scared. They want to leave to visit their family again over there, but now they're stuck here. So that's a problem in our world.
Okay, thank you so much, Ms. Wong. And this last question that we just received, can I file the I-485 without the medical since it's
Uh,
taking very long?
That's right. I would not file the medical without the work. It's just it's okay if you file, because we also have cases where sometimes even I say just file it without a medical. We can amend it later because they don't like us to amend. You either file the medical with the 45, or they'll send you informational letter affirming that we did not get your medical, and make sure I don't want it now, but during interview or something, you have to bring it in. So just to avoid all those stuff, I would file the med. And it's not hard because I have people, because of their shots and stuff, they take about 2 or 3 weeks. It's not that slow nowadays to get
Okay.
medical.
Yeah, so it's maybe this question is because medicals are expensive, and then people file them with the application, and then when they have the interview, they get an RFE to get the medical
Right,
exams again. So it's about $1,200, and some people don't want to spend that money without
right.
having a result from immigration. So thank you so much, Ms. Wong, for having us today, for your knowledge, for your answers, and see you next week, next Wednesday, where we're going to be talking about immigration, answering people their questions, and of course, having a good time hearing from your anecdotes and experiences that you have before. So thank you so much, Ms. Wong, and see you next time. Thank you. And for everybody who has joined us today, don't forget that you can talk to the attorney Margaret W. Wong, and she has been working on this field for over 45 years, and she's the expert attorney uh, who has solved thousands and thousands and thousands of cases every single year. Don't forget that the phone number is 216 279 3984, 216 279 3984. See you next time and keep in touch. 216 279 3984.